Okay, we'll call this hearing back to order. Mr. Challey, one thing, this technology is really slowing this thing down. We got the Elmo up here, we've got written, and we got Mr. Erskine that can help, so we need to move this thing along and not slip back into, after one reminder, slip back into asking the same question over and over and over again, because we've gotten all this, we've read all this.
Understood. Thank you, Mr. Chairman.
Thank you.
Now, Mr. Jones, you said right before we broke that you didn't have certain information that you thought SCENG had regarding the 2015 estimated costs. Isn't that right?
Yes.
Okay. Have you read Ken Brown's deposition transcript in this case?
Yes, I have.
So you've seen that Mr. Brown believed he provided accurate and complete information to the Office of Regulatory Staff regarding the estimated completion presented to the Commission in 2015, right?
What I have seen is Mr. Brown said he provided the information on the Westinghouse estimate, yes, consortium estimate.
Well, let's look at exactly what Mr. Brown said. This is a copy of his deposition transcript that's on the screen. I'm going to flip to page 258. This is my question to Mr. Brown. First, you indicated that you had interacted with the ORS at certain times throughout the project. Is that right? He says, occasionally. Rare occasions, yes. Let me ask you, Mr. Jones, do you recall meeting with Ken Brown in late 2015 regarding the project?
I can't recall the date specifically, but we did meet with Mr. Brown, gave us some presentations on the budget, yes.
Okay. So Mr. Brown then continues to discuss such a meeting in response to my questioning to him. He says, and specifically, or my question to him, and specifically, this meeting you discussed with Mr. Cox, I'm not sure we identified a precise time frame for it, but the meeting with the ORS where you discussed estimated completion. Is that right? He says, correct. And I asked him, do you believe you should be subject to criminal prosecution for any of the information you shared or did not share with the ORS in that meeting? He says, no. Do you believe you made any material misstatements to the ORS at any point throughout the project? He says, no. Do you believe you made any material misstatements to the ORS in the meeting that you discussed with Mr. Cox? He says, no. And then he continues, where I ask him, and do I understand your testimony previously that you believe you did not make any material misstatements because you disclosed three things to the ORS in this meeting? One, that the estimated completion you were presenting is one that came from the consortium. He says, right. Is that right? Two, that there, and then I got confused, thought maybe he had only identified two issues. I say, second, and you tell me if I'm missing anything, you also described to the ORS the current productivity ratios that you had seen the consortium be able to meet. He says, I presented the cost as provided by the consortium. I presented the factors that cost was based on, which were the performance factors, the indirect to direct craft ratios, and the field non-manual to direct craft ratios that the cost was based on. And I also presented the current data for those ratios. And then if we flip to page 260, line 7, I asked, in describing what you received from your contractor in the way that you did is not, in your view, a material misstatement, right? He says, correct. Have you seen this testimony from Mr. Brown?
Yes.
And Mr. Brown believes that he provided complete and accurate information to the Office of Regulatory Staff, right?
Mr. Brown believes that he provided the information provided to him from the consortium. And if you look at other parts of Mr. Brown's testimony, you'll see he was provided with a script telling him what he could and could not say.
All right. Mr. Jones, do you recall Mr. Brown invoking Ray Charles during his deposition?
Yes, I do.
You do know who Ray Charles is, don't you?
I do.
Ray Charles is a blind musician, isn't that right?
Right.
Okay. And Mr. Brown invoked Ray Charles to help describe some of his testimony, specifically what he thought even someone like Ray Charles could see related to the project. Isn't that right?
Very colorful example, yes.
Okay. Let's look at that exchange. That's on page 318. And as we're getting to that exchange, I'll tell you, are you familiar with the fact that Mr. Brown's invocation of Ray Charles was, in a way, tied to a document that Mr. Ellerby has already showed to you today, or yesterday? This is the exhibit, a Michael Crosby to Steve Byrne email. It's included in one of your exhibits, GCG-2.24, with the charts.
That's a little bit too complex for me to follow. I don't understand the point you're making.
Well, what I'm trying to do is I want to get in front of you the email exchange that Mr. Ellerby has already provided to you. So I think it's in the stack that's in front of you, Mr. Jones.
Okay.
You want me to look?
Give me a broader hint.
Yeah, let me help you.
It's exhibit number 17, if anybody's keeping count.
Mr. Chairman, I think that email was not separately identified because it was an exhibit to Mr. Jones' pre-file testimony, and so I didn't offer it separately as a separate exhibit. Maybe I should have, but.
Thank you, Mr. Ellerby.
Okay, Mr. Jones, just so everyone's aware, you have in front of you an email from Michael Crosby to Steve Byrne. Isn't that right?
Yes.
And the email is dated April 6, 2015, right?
Yes.
Okay, and it includes, as an attachment to the email, a series of charts. Isn't that right?
Yes.
Okay, and this is... Well, okay, so this is a document that you discussed with Mr. Ellerby. I will represent to you that on pages 318 of Mr. Brown's deposition transcript, he is referring to this same document. Okay? So let's pull up page 318 of the transcript. Starting with line 1, and I'm going to go through that page, 319, and the very beginning of 320. So I asked Mr. Jones, you said earlier that Ray
I'm
Charles...
sorry, could you increase the size a little bit, please?
You said earlier that Ray Charles could see the issues you had seen related to the status of the project, right? Related to the schedule completion at the current work completion rates. And that's based on information that you had related to historical productivity factors and the various different ratios, I believe it's actually ratios, but in any event, that you identified, right? And then he says, if I can locate it, I can show you what that's based on. And he pulls out Exhibit 16. In effect, the same document that Mr. Ellerby showed to you. And he says, we're getting there. So now, Dan, we're on line 10 of 318. There we go. If I can locate it, I can show you what that's based on. This is exhibit number 16. The next to last curve that is a graphical representation of what I was describing at that time. So I understand. But it's your testimony, this sort of Ray Charles comment. Was that specific to this particular document, or was it broader to the schedule and cost of the project? He says it's specific to the impact represented in this curve. Curve that he is referring to is on page 3 of 4 of the document. And then I asked him, so you're saying, if you just look, if someone provided this document to Ray Charles could understand what it's conveying. Is that right? Yes, of course. That is, there's not a lot of humor in it because Ray Charles is blind. Then he continues. The next page. Right. But this would represent that I would believe anyone could look at this curve if they understood what is represented here and recognize there's a problem. In this, the inputs to this curve, as you understand it, are the productivity factors. Is that right? The input to this curve is the work completed during a fixed period of time and the time remaining in the project to complete the remaining work, which, Mr. Jones, I add, is information you had in 2015, correct?
Correct. I had productivity information, but I think this represents a very oversimplified approach to the project, assuming there's going to be no productivity improvements whatsoever. So it's a straight line in extrapolation of what was done in the past with no improvements at all.
So you'd agree with me that Ken Brown's projection here is unrealistic in light of what the consortium had committed to, right? It assumes no improvement, even though the consortium had committed to substantial improvement, correct?
Well, I'm sorry, when you say Ken Brown's, the curve we're looking at, I don't believe was Mr. Brown's, is it?
But if Mr. Brown is making clear that the graphical representation is what he believes conveys that there's a problem with the project.
No doubt there was a problem with the project.
Okay. And what he says is, with the information you had, the amount of work completed in a fixed period, work completed during a fixed period and the time remaining in the project to complete the remaining work. That's what he says are the inputs to this particular curve. And then I ask him, and the amount of work completed during a fixed period of time was also known to the Office of Regulatory Staff, wasn't it? He says, yes. So the Office of Regulatory Staff could have prepared a chart, to your understanding, very similar to the one that we are looking at right now in exhibit number 16. Mr. Brown says they could have. And then we'll get it on the screen. Then I asked him, and so they could have then known, just as Ray Charles could know, what the issues were in terms of the likely schedule for the project, right? Yes. Would you agree with Mr. Brown? The ORS knew more than enough to develop the same kind of projection that's conveyed in the document Mr. Ellerby gave to you, and which identifies the problems with the project.
This is basically useful for drama, but not very useful in managing the project.
Well, it's your testimony that Ken Brown believed there was an alternate estimate at completion based on an analysis that assumed little improvement in to-go productivity. Isn't that true?
No, that's not true. It assumed some improvement. It assumed what they believed to be realistic improvement in productivity.
When you say they, who exactly are you referring to?
The EAC team.
Okay, we'll come back to that in a minute. That's a team that you believe Carlette Walker ran, isn't that right?
Correct.
What basis do you have to believe that Carlette Walker ran that team?
Well, the latest I saw was her testimony that she led the team. I know she was on the team from other sources, but in her recent testimony, she indicated she led the team.
Okay, is this recent testimony that occurred even last week?
In that case, I did see that. I didn't read the whole thing, but I did see her statement to that effect. Yeah.
Okay. Now, before we get to that particular testimony, you testified on Friday, I believe, that any concerns you had over the reliability of the consortium's cost estimates were alleviated by the election of the fixed price option. Isn't that right?
Yes.
And that's because under the fixed price option, the risk of increased cost to complete the project was on Westinghouse, not on SCE&G or the ratepayers, correct?
That's for the EPC part of it. As I stated in my testimony, there were other costs that were going to be incurred by SCE&G directly, and that were not part of the EPC agreement. But for the EPC, for the construction efforts covered by the EPC contract, that's correct.
And it was true, was it not, that Westinghouse conveyed to you, as they conveyed to SCE&G, that Westinghouse was willing to stand by the project under the fixed price contract, right?
They did convey that, and I believe it was in the August of 2016 meeting.
And then
Senior executives conveyed that to not only me, but to SCE&G, Santee Cooper, and others.
okay. And then based on those assurances you received from Westinghouse, Santee Cooper received from Westinghouse, and SCE&G received from Westinghouse, the ORS, and you personally ultimately supported the 2016 petition. Isn't that right?
That's correct.
Even though all the problems that you knew to exist on the contract, even though all the problems you knew that could make it less likely that the consortium would meet its promised productivity factor, even though the consortium hadn't met its productivity factor as of that time, you decided the fixed price option was such a good deal that it should be approved, right?
I'd say that's generally a good characterization, yes.
Okay. Just a couple final points here, Mr. Jones. So you referred to Carlette Walker's deposition, what I understood you to say, her second deposition, just a minute ago. And you've testified here that your opinions in this case are based in part on what you understand Carlette Walker said about her 2015 testimony. Isn't that right?
Yes.
Because you believe that she was pressured into signing inaccurate testimony in 2015 regarding the estimated completion. Isn't that right?
That's what she stated.
That's not true, Mr. Jones. It's not true at all. Have you read the transcript from day 2 of Ms. Walker's transcript?
Which one?
Day 2.
No, I'm talking about which she's made several depositions. I don't know which one you're talking about.
The second instance in which her deposition was convened, which was last week.
No, I have not read that.
Haven't seen it?
I've not seen it yet.
Did you get any reports on what she conveyed during that deposition?
The only report I got was that, and I happened to be listening to the, it was live streamed, and I happened to be listening to at the time she said that she was the leader of the EAC team. That's about the only additional information I got from that.
You were, I'm sorry, were you listening into the deposition?
In someone else's office. I wasn't listening in constantly, no.
You were just listening into specific portions of it, is that right?
It's happenstance. I went into a gentleman's office that was listening to it, and I heard it as it was in the background.
Okay, was this an ORS attorney?
No.
Whose office you were in?
No.
Was it an attorney of some other party?
No.
Whose office were you in?
Gene Soltz.
Gene Salt was listening to Carlette Walker's deposition transcript.
Yes.
Excuse me, deposition last week.
Deposition, yes.
Did you announce yourself when you joined in that deposition?
No.
Okay. But the only thing you can recall is Ms. Walker's testimony related to that she says she led the EAC team.
It was just total happenstance. I had thought she had led the EAC, but I didn't have any documentation of that. But when I heard her say so, then I added that.
So you would agree, would you not, that Ms. Walker's deposition and her testimony in this case is critical to your opinions, right?
I think it's an important part of my testimony, yes.
So does it surprise you to hear that Ms. Walker admitted that her testimony in 2015 was accurate?
That would surprise me, yes.
Okay, let's look at it. Would it surprise you to hear that she said she had multiple opportunities to review that testimony and she ultimately approved it?
Would that surprise me? No, because it was filed.
Yeah, so you knew from the fact that it was filed, she signed it under oath, that she believed in 2015 that it was accurate, correct?
That would have been the case with her filing the testimony.
And further, that she appeared live in this commission and adopted the very same testimony that you're now contending was inaccurate.
I'm not contending it. That's what she said in the deposition.
Nope, not at all what she said in the deposition. Let's look at it, Mr. Jones.
Which one are you going to?
Now on day 2, the deposition that you only heard a small piece of, this is the rest of it in pertinent part.
I'm not talking about this one. I'm talking about our previous deposition. I did not see this or hear the whole deposition. So
Okay, well, let's look at what she
can't
said.
attest to anything in this except that I heard her say she was the leader of the EAC team. That's all I heard.
Okay, here's the transcript from Ms. Walker's deposition, day 2. She's asked 108 to 109, 108 line 23 to 109 1. In your testimony before the Public Service Commission that was presented and you validated was true and correct, was it not? It was. Ms. Walker is saying here that her 2015 testimony was accurate. Was she not?
I don't know what she's saying.
Does that impact your opinions in this case?
No, because I saw her previous testimony that she stated she was forced to submit false testimony.
So her sworn testimony in response to a direct question that her 2015 testimony was accurate and her acknowledgement that it was has no impact on your opinions here.
No, sir. I'd have to see context because if she's attesting that it was accurate relative to what the consortium had presented, she would be correct.
She's saying her testimony is accurate, Mr. Jones, and let me give you exactly the context you're looking at. Can we go to tab 20? Have you seen this document before, Mr. Jones?
I don't specifically recall. There's similar documents that I've seen with back and forth with Carlette and other people, but I don't know if this one.
Okay, here's an exchange between Carlette Walker and Kevin Cocombs. You know who Kevin Cocombs is, don't you?
Yes.
You know that Kevin Cocombs was in part responsible for preparing certain charts that went into Ms. Walker's testimony in 2015, correct?
No, I don't know that. I'm not surprised at it, but I don't know that for sure.
Okay, so let's look at what Ms. Walker tells Ms. Cocombs, or Mr. Cocombs in 2015 regarding her testimony. Kevin responds, Carlette, I'm glad I could help. And if you look at the rest of the email, it's clear that it's in connection with the 2015 testimony. As I know you would do the same thing for me. I just hope you are happy with how your testimony turned out. What's Ms. Walker say?
She says, I'm very happy with it.
So in 2015, Ms. Walker not only swore to the accuracy of the information she was providing, not only reaffirmed the accuracy of it in live testimony presented to the commission, not only swore just last week that it was accurate, in contemporaneous documents in 2015, she's indicating that she's happy, doesn't have a problem at all with her 2015 testimony. Isn't that right?
That's what it stated, but in the same token, it doesn't refute my contention that she's happy that it reflects the results of the consortium estimate. I don't see where it conflicts with that.
You didn't even know she sent this email to Mr. Cocombs at the time, did you?
No, I readily admit I didn't know she sent this email.
And you didn't know that last week she testified that her 2015 testimony was accurate?
Did not, because I did not see the deposition transcript nor listen into the entire deposition.
And it's your opinion in this case that your testimony before the commission isn't in any way impacted by these facts that you now know?
No, it's not.
Thank you, Mr. Jones. That's all I've got.
Okay, thank you. We go to Dominion. Okay. All right. That moves us to commissioners. Any commissioner questions? Mr. Jones. Mr. Elam.
Good morning, Mr. Jones.
How are you, sir?
I'm fine. Fine. It still is morning.
Get
I'm
Closer to
waiting,
your microphone.
I'm waiting for the clock to change back again. You testified, and I think it's been brought out, you testified in the 2016 proceeding here on the changing costs.
Yes, sir.
Is it fair to say in that testimony you were communicating some real concern about the project being able to meet schedule? Is that correct?
Yes, sir. And I think if you look at my testimony, it's all couched on the just lost the word, the agreement, settlement agreement. Thank you. There it is.
Okay. There's also, that was introduced on Friday, I think it's hearing exhibit 23, is a memo, I guess you sent to ORS dated June 27th, 2016. You familiar with that?
No, sir. I'm sorry. I'd have to see what you're talking about.
Can you get him a copy of hearing exhibit 23?
I probably got it here in front of me. I just don't know what it is.
Yes. Summary of June 2016 site visit and recommendations.
Okay. Yeah, I'm kind of with you there.
Okay. And it's sent from you to Brittany Waring.
Yes, sir. Yes, sir.
Okay.
Thank
Is it fair to say that memo is even a little more critical than your pre-file testimony?
Yes, sir. At this time, things were going. They continued to not meet our expectations. In June, Fluor had been on the job for 6 months, essentially. I had expected a significant turnaround when Fluor came on board. Actually, I expected a step change. It had not manifested itself, so yes.
Okay. My understanding for that ORS's position is that pre-March 12th, 2015, you haven't cited any problem with costs or the schedule or anything else at that point, that you're not trying to go beyond March 2015.
That's correct.
Okay. I believe you were discussing a bit with Mr. Challey about ORS being able to do its own independent comprehensive assessment. You recall that? Your own timeline?
Yes.
Is that something you would have been able to do?
I mean, there's several things. I mean, it's correct that I could have taken and extrapolated the existing productivity factors. I never thought that would be a worthwhile exercise because I thought there were going to be improvements in productivity. And a schedule assessment is different than developing the entire schedule. Developing an entire schedule is a very complex process. Developing a schedule assessment is not as complicated as developing an entire schedule.
You were given a look at an INPO report. Would that have caused you to change your opinion about the project?
No, sir.
Thank you. That's all I have.
Thank you.
Commissioner Williams.
Thank you, Mr. Chairman. Good morning, Mr. Jones.
Good morning, sir.
I have a couple of questions for you, sir. On page 10 of your pre-filed direct testimony, you state that SCENG on March 12, 2015, filing under docket number 2015-103-E, was seriously deficient and presented unsubstantiated, misleading, and baseless estimates of the revised project construction schedule and costs. The first question, sir, is did ORS review the filing in docket number 2015-103-E?
We did.
Could ORS have identified the problems that you noted at that time? Why or why not?
I think the real question comes down to, were we provided all the information that we needed to do that? With the information we were provided, I mean, this looked like, what was my word that I used? That it was, it could be construed to be accurate, could be construed to be adequate information, but in fact, information was withheld that we weren't aware of. In the case of the schedule, the information that I think was really important was what SCE&G actually believed at the time that they could do, that the contractor could do, that they would be able to get them to do. And what they withheld was that they had absolutely no confidence in what the consortium had presented to them. That was not conveyed to us. Did we know there were issues? Yes, we did. Did we know that it would require considerable effort on the part of the consortium in order to improve their productivity and improve the schedule? Yes, we did. Did we know that SCE&G had absolutely no faith and that they believed that the schedule was unattainable? No, we did not. With regard to the cost, I think it would, and again, it was a unilateral decision on their part to withhold the cost estimate that was done by their EAC team. Had we in fact known that their EAC team had come up and believed that their schedule, their cost represented a more accurate portrayal of where the project was going to go, that would have played a significant role in our review, but we did not know that. So I just remember the word again, plausible. It was a plausible cost estimate. It was a plausible schedule, but it was not accurate, and we did not get the full information.
I want to probe a bit with you, Mr. Jones. When you say SC&G had no faith in the consortium's numbers or their productivity or however you want to phrase it, what information are you using to make that determination?
There were several exhibits in my testimony that provided you with examples of where they made such statements, and that's really, as this information came out in discovery, that's the basis of what I'm saying now.
Could you be a little bit more specific? There have been several exhibits entered in since your direct and cross. I completely understand that you believe. I wrote down some words that SC&G mismanaged. They presented misleading information, and in fact, they were deceptive. And I'm just trying to, based on all the exhibits that have been admitted, it seems as if there's a little bit more to the story than that. So I'm just trying to elicit from you, when you say they did not believe that the project could go forward as presented, is there any specific evidence that you're standing on for that?
I mean, it's the statements that were made in the exhibits. I'm sorry, I can't identify which ones specifically, but they're in the timeline that we're talking about here. They're in the fall of 2014 timeline, and there were several examples that were pointed out where they just had no confidence in the consortium's ability to either develop or meet a schedule.
So I'm just a little curious about your role as the monitor. You were the monitor for this project, correct?
My duty was to assist ORS in monitoring the construction and the cost. Yes.
Okay. So what does that really mean?
Well, it means that I take a look at what's going on in the construction of the project. and based on the information that I have, make an assessment of whether I believe that what I'm being told relative to the schedule and what I'm being told relative to the budget are, in fact, true representations of what's going on.
Understood, sir. Who did you report to?
Well, reporting is kind of, I mean, I worked with various ORS staff. The lead person for most of the duration of my assignment was Ms. Allen Powell, but also reported to Mr. Anthony James, who's going to be a witness here. And administratively, most of the time for my assignment, I reported to Ms. Shannon Hudson.
Understood, sir. Final question. I think it's Exhibit 27. It's
I'm sorry, in my testimony or this exhibit?
it was recently admitted Exhibit 27 by the company.
Okay, sorry, sir.
No, that's fine. It's dated May 22nd, 2015. And this is
Yes.
a document that you drafted, I believe. Is that correct?
Yes.
And it appears to me that there's a question about the productivity factor. And essentially, you were asking why they decided to use a different productivity factor other than a 1.15. Is that a fair summary of your question? Question one?
No, sir. I think the question is why they were using the 115, not why. My question was, why did you choose to use 115 when actual values have been considerably higher than that?
Right. Did you ever consider bringing this information before the commission?
Productivity factor information? No, not really. I mean, I think that what would be manifest in the what I would address to the commission is factors, the actual numbers themselves. I mean, I mentioned productivity in my testimony, but I'm not sure that I gave exact numbers. But it would be manifested in the schedule that these would have a direct impact on the schedule, whatever productivity factors you use.
I thought that would be my last question, but this is actually my last question. What would you have wanted the company to do, or how would you have wanted them to present the information you feel they didn't provide to you in a manner where you would have believed it was necessary to report that information to the commission or to sound an alarm or ring a bell?
First off, I would like for them to have been truthful. With regard to their intent to do an assessment of the project, their March 12th, 2015 filing, and this has been pointed out in our testimony, was highly unusual. That filing was based on preliminary information that only they had developed. The consortium was not part of it in many cases. Usually, when they came in with filings, we had completed change orders for the project that at least had been accepted by the consortium, if not approved by the consortium. So, in addition to that, all in the past, change orders, not only did we see the basis of the change order, but we saw the analysis that SCE&G had done in support of that change order. In this case, what we saw was in support of their estimate. We saw the basis of their estimates, but they were their estimates. So, and with regard to the schedule, always before they had come in with a change order in the contract that indicated the same schedule dates as they were presenting to the PSC. They did not do that in this case. They presented what we thought was okay, it's plausible, although it really wasn't. The dates they don't have to present the same dates that are in the contract. I mean, they could have had the contract signed, and they could have held the feet to the fire of the consortium, regardless of that. I mean, so okay, we accepted the fact that the dates weren't the same that were being presented as were in the contract. That was unusual, but we went with it. We're very suspect relative to the real basis of that schedule and how it had been developed because we hadn't seen it. They had not been able to present that integrated schedule to us for us to take a look at. So, in that environment, with the very unusual presentation that they'd made in their March 12, 2015 filing, combined with the fact that they were that at that time they were going to do an assessment of the project, or in deference, if they had decided soon after that during the review process that they were going to do an assessment of the project, my recommendation would have been that we hold the review of their filing until that assessment was completed and we had a chance to review the results. That would have been a whole different ballgame. There was no specific reason that they had to wait until August to authorize that assessment. It could have been done, if it had been done, authorized shortly before or even after March 12, 2015 filing, we'd have gotten results and reviewed that. Most certainly, if we had seen that the Bechtel report indicated the dates that we were talking about, what we would have, I'll say this in my own context, what I would want to have seen is for the consortium to address those dates. Why does Bechtel come up with these dates? Because they were based on their own unit rates for doing work, their own quantities for doing work, and those kinds of things, modified some by their interface with Westinghouse. But we would have wanted that correlation to take place between the consortium schedule and the Bechtel schedule. So that would have been a whole different ballgame. I don't think we would have been at this point. I think they would have had ORS on their side if we'd gone through that whole initiative at that time. If they'd faced up to the fact that they were going to do an assessment, that it required some additional analysis to justify what they were doing, they could have worked on also better defining their cost estimates and getting their act together relative to having change orders in place for those cost estimates. So I think we'd be talking about a whole different ballgame. Granted, there could have been some issues. And one other point there, if we had known that their estimate in completion was $1.2 billion instead of the 678 or 87, whatever it was, million, I think they rightly realized that would have raised eyebrows, and I think it would have raised your eyebrows if they'd come in for a $1.2 billion cost increase. I think there would have been a whole different review regime that happened at that time. So that's why the March 12th filing is so important, is that it was suspect somewhat from the beginning. If we'd known they were going to do an assessment, it would have been even more suspect, and it would not have been reviewed in its form at that time, and we would have gotten the Bechtel assessment completed and factored that into our review before any settlement agreement was reached at that time.
And just to clarify, when you use the word assessment, you're specifically referring to the Bechtel report?
Yes, sir.
Thank you, sir.
Thank you.
Commissioner Whitfield.
Thank you, Mr. Chairman. Good morning, Mr. Jones.
Good morning, sir.
Mr. Jones, I've got some questions. Some are more specific, some are more broad in general. So I'll kind of start and go that way. You said you came on site in 2011, right?
Yes, sir. August 2011 is when my engagement with ORS began.
A few years after the initial application was approved by this commission.
Yes,
and I want to ask you a little bit about specifically about your knowledge about personnel. I think when Mr. Ellerby was questioning you, you were a little bit uncertain about what Mr. Jeff Archie does or what his title was. Could you clarify your knowledge of what Mr. Archie did at the time you came on and what he did, what his title is, what his role is?
Again, I'm not absolutely certain, but I believe he's Chief Nuclear Officer for SCENG.
You mean now?
I don't know now. Honestly, I don't know what his position is at the current time. He was at the time of the project, I believe.
What was his position or title or his role when you came on the project in 2011?
Actually, I do not know at that time. I became aware of Mr. Archie and his role later on. I didn't have much interface with him, I'd say, for the first couple of years of the project, but then as it went on, the interaction with him expanded. In fact, we would have periodic meetings with, usually after our monthly meetings with the senior people on site, we would have a debrief at the site with Mr. Burns, Mr. Archie, Ron Jones sometimes, and the attendance varied based on their availability. But
so you did have some interaction with him?
Yes, sir.
I'm just curious, with him being at such a high level, that you were a little bit confused, if you will, as to what his role was.
Yeah, I just don't remember his title. That's
all right.
I know he's a senior executive at SCENG.
How about Mr. Alan Torres? Was he on the job when you came on in 2011 for SCENG?
I believe so. I believe Alan was there for the entire duration of my tenure, I believe.
Are you aware he testified before this commission several occasions initially, and what do you know his title to be?
He was the lead construction guy on site.
And how much interaction did you have with him?
Fairly extensive interaction with Mr. Torres.
And where is he now?
I don't really know. My understanding is that he's no longer with SCENG, but I don't know that for a fact.
All right. Thank you, sir. Let me ask you a little bit, and this is kind of more general. And, you know, we have to go by testimony and evidence and so forth in these proceedings. But there have been a lot of reports in the media, and we have to stay away from hearsay and rumors and innuendo, but I do want to address one. There are a lot of reports have been in the media and rumor and conversation, and some in Ms. Walker's testimony about abuses of materials and sloppy work, incorrect work, even a story about the whole third shift sleeping. I know you might not have been out there on the third shift, but you all, with 3 or 4 of you being on site, can you address some of these accusations and, for lack of a better word, in some cases maybe reports or rumor? Could you address some of these? Did you ever make a midnight visit out there to see what's going on?
No, sir. We did not go out there. My visits to the site were usually on a monthly basis, and I did not observe what there is being alleged in these articles that you're talking about. I never observed that.
You never saw anything like that?
No, sir.
All right. Ever heard anything like that?
No, I never even heard. There were always issues of individual, people failing drug tests, being escorted off site, those kinds of things, but no big widespread incidents that as you're talking about.
Well, I'm familiar with construction sites. I've worked on quite a few of them. So, and sometimes there is chatter, if you will. So you're going to just kind of anything of that nature was just in your mind was just that.
Yeah, I mean, you always have issues on a construction site. There's always something going on. I mean, you know, there's occasionally there's injuries. Occasionally people get sick. I mean, 2 or 3 times there were ambulances that showed up on site during our time there and that kind of thing. But it's a construction site and things happen there. But I heard of nothing in the widespread nature that you're talking about.
Let's talk about another individual with the company who's no longer with the company, Mr. Steve Byrne. He's testified before this commission numerous times, and several of those times he mentioned an exchange program, if you will, that SCE&G had with the Sandman nuclear station in China, where the first 2 AP-1000s are in the world. You familiar with those exchanges the company had with China and maybe some of the lessons they might have learned?
Yes, I would say awareness rather than familiarity, but I'm aware that they did send people over to witness some of the pre-op testing at Sandman, and I'm aware that they had very close and you know, in the latter stages, frequent visits at Sandman. Yes.
You told one of the attorneys, I don't think it was Mr. Ellerby, but it might have been one of your attorneys from ORS, maybe Mr. Richardson, I'm not sure, but you made the comment that that they didn't have an EPC contract over at the Sandman units. Is that the way you understand it?
Yes, sir. The Chinese did most of the construction on the Sandman projects. The Chinese did it themselves, the Chinese construction companies. Westinghouse had a responsibility to do construction management, but the Chinese did the construction. The craft labor wasn't directly under their responsibility, is my understanding.
It's fair to say that, I guess I'm going to kind of characterize what you're saying. What you're saying is the E and the P part of it, China National Nuclear Power Company did themselves, and they brought Westinghouse in kind of laser focused to do the C part, the construction part. Is that what you're telling me?
No, it's probably the other way around. Westinghouse did a lot of most of the engineering Westinghouse did. A lot of the procurement they did, but not all the procurement. And they had fairly restrictive limitations in their procurement. They had to procure a lot of stuff directly from Chinese suppliers. So big equipment, no. I mean, when I'm talking about big equipment, I'm talking about things like steam generators, reactor vessels, those kinds of things. They didn't necessarily come from China, but a lot of the commodities and that kind of stuff, there were strict requirements that they had to. And then most of the construction management, as I understand, and the Chinese contracts are not transparent, by the way. I mean, but from what I'm aware of in the industry press, most of the construction work was done by Chinese contractors.
And you're saying that Westinghouse still had, you're still saying, though, that Westinghouse had the authority or was over the craft labor. Is that what you're saying?
They did construction management. I can't address really how much authority they have over the craft. I don't think they had direct responsibility for the day-to-day craft. So it's a little different arrangement than the consortium. And the other thing I would point out relative to the Chinese plants is they also did not have the complicated shield building. The Chinese decided they did not need aircraft impact capability on their plants, and so the design of the shield building was somewhat less complicated than both Summer and Vogel.
While you wouldn't characterize it or you characterize it differently from the EPC contract that SCNG had here. You are acknowledging there was some type of agreement in place, right?
Yes,
Okay.
yes, definitely.
All right. What do you know about, since those units now are in service? The first one, what do you know about cost overruns or the timing schedule, how early they started, when they finished, or any kind of lessons learned? I'm saying if SC&G acknowledged their program exchange, whatever you want to call it, with the plant and Sandman, and they've come back and talked about their joint lessons learned, if you will, certainly ORS could have benefited or had access to that information. Is that right? And if so, what can you share with me about any cost overruns, schedules, milestones, how any of those things? Yes.
And honestly say, no, virtually nothing about cost. And that's not unusual with Chinese projects. They don't really publicize their costs that much.
They don't have rate cases over there, do they?
Correct.
All right.
Schedule-wise, they were, it wasn't done right on schedule. I don't recall off the top of my head, but I think they had somewhere in the range 2 to 3 year delay. But don't take that. I'd have to look at additional information. But they were late in their schedule. The schedule was delayed, which is fairly unusual for Chinese projects. They're usually, especially the domestic ones, they come in pretty much on schedule. And they say they come in on budget, but you never know what that is.
What is your knowledge about, or could you describe your knowledge of how late you think they were?
Well, as I said, I think they were 2 to 3 years late, but don't take that as gospel because I don't remember exactly.
Let's shift gears just a little bit to Santee Cooper just a little bit. I think that one of the opening statements was made that by one of the company attorneys that the two things that caused this event was Westinghouse's bankruptcy and Santee Cooper announcing it would walk away from the table. We've never been able to, until this proceeding, we've never had a Santee Cooper witness here before this commission. So would it have been prudent for the company to have known more about Santee Cooper's generation's needs, or did ORS know any more about Santee Cooper generation? The only thing this commission knew is that there was a change in the percentage of ownership years ago in the project. And the commission was made aware of that. But could you share any more knowledge you might have had about Santee Cooper's generation needs and their decision to walk away from the project? And did SC&G know of that sudden decision? Of course, we all knew about the bankruptcy of Westinghouse in March, but I think it's been said here before that this commission was pretty blindsided by the news we got on July 31, August 1 of 2017.
Some of the stuff I can't comment on. What I would indicate to you is that we were very surprised in the discovery process to find out the fairly extensive involvement of Santee Cooper in the project. In general, the impression that we had relative to Santee Cooper's involvement was essentially a silent partner. Their on-site representative very rarely said anything during the meetings until the latter stages of the project. or the meetings that we had privy to, the notes and that kind of stuff. There were very little input came from Santee Cooper. We're very surprised to see the extensive interaction that they had with Mr. Marsh and some of the senior people. We had never seen that. We're not aware of Santee Cooper's fairly proactive involvement in the project. So, as I said, we thought they were pretty much a silent partner, leaving all the decisions to SCE&G, and we had hardly any interaction with Santee Cooper. Did not know any of the details about what their plans were relative to withdrawing from the project until they did so.
At the time Santee Cooper had their board meeting, made that announcement, I think just within hours, SCANA made their announcement. And there was currently an interim agreement in place with Westinghouse, I think, to the tune of approximately $30 million a week. In your mind, what options did SC&G have upon receiving the news from that board meeting? The interim agreement, I do think, lasted another 10 days, which would have been about to August 10th, as I recall it. But what other options did they have other than, I guess, of course, they had their contract with Santee Cooper, sue for specific performance to continue. What, in your professional opinion, what other options were available to the company at that time?
Well, truthfully, I don't believe they had a lot of options available. I mean, there are theoretical things that could have been done, but losing 45% of your input to the project, or cost sharing with the project, I think could be described as a devastating blow. I mean, in theory, they could have pursued going alone on the project. Don't really think that would have turned out to be viable. In theory, they could have pursued another partner. Don't think anybody would have been interested. So I think their options at that point were really factually pretty limited. I don't think they had a lot of choice.
I have an accounting question along those lines, but I'm going to save that one since that's not your area, and I'll maybe direct that to another witness so you don't have to punt it here in front of me.
Thank you very much.
But I do have one final, and Commissioner Williams asked you a lot about the 2015 filing. And I'm not going to revisit where the road Commissioner Williams went down, but I do want to fast forward just a little bit, and I think Mr. Challey was asking you about the 2016 fixed price option. And in your testimony in 2016, you do state a lot of concerns and you acknowledge a lot of things, but yet in that proceeding, of course, you acknowledged to Mr. Challey, that you went along with the fixed price option contract. In your mind, did you think, obviously, that was going to make, I think you stated that you thought they could meet the 18-month window still, but in your mind, did you think these concerns that you stated here in the 2016 case were going to be resolved? And if so, had you done any studying, if you will, or anybody on the ORS team done any studying to the financial solvency of both Westinghouse and Toshiba? I know that's two questions.
Yeah.
I'm sorry. That's a two-part.
Okay, let me, with regard, just one clarification. In my reference to making the 18 months was to the 2015 filing. But I believe.
I'm sorry. Okay, fair enough.
Okay, with regard to then the question of what I believed at the time, and based on the input that we had gotten from Westinghouse, that this was they recognize the importance of this project, these projects, but specifically summer. They recognize the importance of these projects to their entire future. And at one time, I believe there were, the numbers vary, but it was pretty close to having at least 12 nuclear projects authorized by Westinghouse. And I think that the line went up to, in theory, like 20 something. So there was in the time of the 2008 timeframe, there were a lot of people that were lining up to do Westinghouse projects. So if they want, and not only in the United States, but internationally also. So I thought that Westinghouse, when they gave that assurance, I thought they were sincere. I didn't take that totally at face value. I also looked at the backstop by Toshiba. Now, Toshiba was having considerable financial problems, there's no doubt about that, but I never believed that the Japanese government would let Toshiba go under. And thought or opinion turned out to be the case. Toshiba did not go under, and just as I thought they would never go under. What I didn't know at that time is actually how much money had been lost on the project previous to that time, and Toshiba's position relative to basically telling Westinghouse, we're not going to do this anymore. Did not know that. So I didn't expect Toshiba to totally cut Westinghouse loose and just let them drift into bankruptcy and cut their losses. I really never expected that, because I thought that the nuclear market was very important to Westinghouse and to Toshiba, and they would finish both these projects in order to maintain that. We didn't do, to my knowledge, and I guess I can't really specify for all of ORS, but to my knowledge, we didn't do extensive financial assessments. And actually, I don't think it would have been available to us to do that. First off, the Japanese market is not all that transparent to us, and what's going on there is not all that transparent to U.S. entities. And Westinghouse was holding things pretty close to the vest at that time, too. I mean, we saw the general reaction of market analysts and what was going on, so we knew there were issues. But at that time, I honestly did not think that Westinghouse would go into bankruptcy. Now, I want to emphasize that if we had seen the dates from the Bechtel report, that's a whole new ballgame. Because if you take and stretch out the project to those dates, you're not talking about losing $1 billion. You're talking about losing maybe $3 to $4 billion or more. And that would have caused a little more pause in saying, okay, how much is Westinghouse really? How much can they lose going out that far? So I think it would definitely have impacted us to know the Westinghouse, the Bechtel assessment dates, and I think it would have caused us to probe more into the possibility of Westinghouse bankruptcy. Their insolvency would have been much more likely, knowing the dates extended out that far.
Well, I was about done, but you triggered a couple of more questions. Speaking of Bechtel, did you or a member of the ORS staff, I don't know, you came close to saying that since you've been on the staff, did either you or a member of the ORS team pursue the Bechtel reports or pursue something once you saw that Bechtel hard hat leaving the room that day? Not you or Mr. James or Ms. Powell or anybody?
No, sir. We believed that, and I just want to say, when somebody comes on site to do an assessment, that the definition of that can be very broad, wide. The general impression that I got was this was maybe a couple of Bechtel executives or
Visiting.
visiting the site, and or a couple of managers, like the guy with the hard hat, and taking some, I'd call them softball type recommendations back to the SCE and executives. Like, you should tweak this a little bit, or you should do that. We had no idea that there were 10 senior managers on site, and they'd been there for 7 weeks. So it was an entirely different. Would have been an entirely different perspective if we had known that.
Understood. Back to the market of Westinghouse, market in their services, and back to China. To your knowledge, how many new nuclear plants are proposed or under construction in China?
I believe there are 12, and again, I've got the information but don't have it memorized. I believe there's currently 12 nuclear plants under active construction in China. And that varies because some are coming online and move out of the designation as being construction and go into commercial operation. My best remembrance right now is there are 2 Chinese Westinghouse AP1000s that have been declared commercial. One at Haiyang and one at Sanmen. The second unit at Sanmen is producing power but has not yet been classified as commercial operation. 4th unit, which is Haiyang 2, is scheduled to begin commercial operations by the end of the year. So there's going to be 4 AP1000s there. But there's also, China is going full bore. I believe they have somewhere in the range of 21 additional nuclear plants scheduled for construction, but I think they have roughly 12 in active construction.
And how many you're saying proposed and over what period of time, or do you have that?
Again, I would need to do it, but my recollection is there's about 20-some plants that are supposed to begin construction before 2030, I think. By 2050, China is supposed to have more operating nuclear plants than the United States. We currently have 99. They're supposed to have more than us by 2050.
And is it your understanding that Westinghouse is talking about their market, is going to build all of those? Are they building them in other countries as well, or what could you share about that?
Well, Westinghouse is out of the build market. They're not going to build anymore. What they're going to do is revert to their original role, which was what was called a nuclear steam supply system provider. And that means that they do design of the main reactor systems and the main safety systems. They do procurement on a lot of the big components. They help you with the licensing process. So they're going back to where their core business was, which was to be a nuclear steam supply system supplier, not a contractor. They are out of the construction contracting business, both internationally and domestic.
Yes, sir. And lastly, Mr. Jones, with the company stating that 93% of the components were on site and them having possession of 99% of all intellectual properties, how shocked was ORS to learn that they were calling the project off?
We were very shocked. I mean, not based on this. Once the circumstances were known, I can't say we were shocked after we knew that Santee Cooper, but that happened pretty rapidly. Once we knew that Santee Cooper had backed out, I can't say we were that shocked, but we were shocked. The big shock was Westinghouse going bankrupt. That was a huge shock.
Well, thank you, Mr. Jones. That's all I have, Mr. Chairman.
Thank you. Commissioner Howard.
Thank you, Mr. Chairman. Good morning, Mr. Jones.
Good morning, sir.
Were you here when Dr. Cooper testified?
Yes, I was.
Dr. Cooper, and I read, in short, there are 4 bases to disallow cost, any of which alone would support the finding of imprudence. Combined, they present an overwhelming case for disallowance. The first one is mismanagement of the project. The second one is misrepresentation of the chaos in the construction process. Third is misunderstanding the economic reality in the electricity sector. And fourth, misrepresentation of the Baseload Review Act. Do you agree with Dr. Cooper that either one of those items alone would justify disallowance? Mismanagement of the property, chaos in construction site, economic reality of the electric sector, and misinterpretation of the Baseload Review Act.
I would say not fully. When you say chaos at the construction site,
Oh, that was the one I was going to specialize on you on. Did you see chaos in the construction site?
I wouldn't say chaos. What I saw was that they just could not get the construction productivity under control. It just the production that they needed in order to eventually complete the project was never there. I would not characterize it as chaos. I would characterize it as it was a very challenging environment, and there was things that needed to be done that just didn't get done.
Well, I won't speak for my other commissioners. I'll just speak for myself. But I never noticed any of these 4 things being listed in any reports to us ORS. Were they?
Would you run over those again, please, sir?
Mismanagement of the project.
Right. That.
Go ahead.
I don't think that we would have mentioned it. And as I stated in my testimony, it's only after I found out they were basically misleading and lying to us that I believe that was the primary thing that would result in my saying there was mismanagement. So we did not testify to that before the commission, but we did not have all the information that would have supported that.
We discussed chaos, so let's move on to the economic reality in the electricity sector.
That one is I would say highly debatable, and the issue becomes when do the plants become uneconomic to build, and based on the information that we had at the time, they really were not uneconomic. So it was something we wouldn't bring up because at the time we believed that they would have still been economic. That could have been impacted definitely by the Bechtel report dates. If we had evaluated those and looked at pushing the plant out that far, you'll hear later from Mr. Richardson, if we had used those dates back in 2015, the plant would not have been economic. So that would have been a debate that we would have had here relative to the plants being uneconomic didn't automatically disqualify them from being completed. But it certainly should have been discussed.
And what about misinterpretation of the Baseload Review Act?
You're getting into legal there. I mean, all I can tell you is that I think we were misled, misinformed, and eventually that gets to the point where you have to say they weren't in compliance with Baseload Review Act because they did not provide us with all the information that they needed, and they misled us and used deception to get their cost and schedule changes advanced before this commission.
And you did agree that none of these were presented to the PSC?
I do agree with that, yes.
Thank you very much.
Commissioner Hamilton.
Thank you, Mr. Chairman. I realize the time is getting close to lunch. I'll be very brief. How are you today, Mr. Jones?
Oh, I'm doing great.
Mr. Jones, you know, under the Baseload Review Act and the organization between the PSC and the ORS that you were the nuclear construction expertise for this commission. And you've told us numerous times today that full word was not brought to us, and I just wonder why. That was your responsibility to keep us informed. What stopped you?
I think what stopped us is that we weren't getting the true story from SCENG, and there was information withheld that we should have had.
Okay, and through your settlements and all these things, nothing ever came out that important enough that we should know more about what.
I mean, based on what we knew, sir, I thought that we presented to you that there were challenges. Did we think that the challenges were going to end up where we are now? No, we did not. But the challenges were identified. It's just that we didn't know the full extent of them because information was withheld.
About this same time, I don't have the exact date, this commission received a letter from ORS concerning a survey they've made that time fixed price option would save the ratepayers $1 billion now and $4 billion over the life of the contract. Are you aware of that, or were you a part of that study?
No, sir. I have the awareness of it, but I was not a part of that study.
Thank you very much, Mr. Jones.
Thank you.
Thank you, Mr. Chair.
Thank you. Commissioners, any other? Commissioner Urban.
In some construction projects, the owner goes out and purchases a performance bond. Is any such thing available in the nuclear construction industry? Could SCENG, for example, gone out at Lloyd's of London and said, we want to buy a performance bond for this project to protect us in the event that Westinghouse goes bankrupt?
I'm not really expert in this field, but what I do know is a performance bond on a nuclear project has always been prohibitively expensive, that it costs so much to buy it that most utilities elect not to do so.
Do we know that they ever try to get a quote for a performance bond for this project?
I do not know that, sir.
Have you ever worked on a project where they had a performance bond?
No, sir, I have not.
All right. I believe that you testified earlier Friday that you at one point had recommended to SCENG that they obtain the services of Bechtel. Was that your testimony?
Not of Bechtel. Bechtel was one of the organizations. They had asked me for my recommendations on who I thought would be the best to do a project assessment.
Very few people in this type industry. It's probably just a couple, the 3 companies that could do this. Is that fair to say?
Yes, sir. My recommendation were Bechtel, Fluor, and my old company, Sargent Lundy. And I think I even gave second-tier representatives that could do that, but the top 3 were the ones I stated.
Did you work with Bechtel before in any of the projects that you previously worked on?
Yes, sir. I had worked. We worked with Bechtel in many capacities. In some cases, we were subcontract. Not me personally, but my company, my old company, Sargent Lundy, was a subcontractor to Bechtel. On some, we have worked with them in joint teams, like when I worked on the Watts Bar effort. There was a team of Admiral White brought in essentially every big AE that he could get, and we were a team of 4 different AEs working on that plan at one time, and it included Bechtel, Stone Webster, and I I've forgotten who the fourth one was, but I don't think it was Fleur at that time, but it was somebody similar.
So when you made this recommendation to SC&G, these are the ones that I would recommend, did you have any kind of follow-up contact with Bechtel or any of the other ones you suggested to say, hey, I'm going to recommend that you do this? You might be on the lookout for a call or anything like that?
I did have follow-up with one, and you can probably guess who that was. That was
Your old company.
My old company, yes.
But other than your old company that didn't get the job, did you ever contact Bechtel?
No, sir.
Okay. So the first time you were aware that they might be involved was when you saw the Bechtel guy with a hard hat on site?
I didn't see him, but my colleague.
Or someone did?
Yes.
Okay. And did that sighting, so to speak, make you curious that perhaps they had signed an agreement or about to?
Well, at that time, I guess it was over.
They were 7 weeks into an 8-week review.
Yeah, my curiosity was piqued enough to ask the question that you saw in the October 27th, 28th, 2015 agenda, and it was, I think the reaction of anyone in my capacity would be, okay, you did an assessment, tell me what the results were. And that was the extent of that.
And I saw the agenda item that you had drafted 10 top concerns, words to that effect. Did you ever get into those concerns specifically?
No, sir. Well, as I said, what we were told was they didn't identify anything new. And as I have always stated, the issues on the project we were pretty much aware of. So the fact that they didn't identify anything new, it's a no, never mind. There's no written report. There's not going to be a written report. So that as far as I was concerned, that put the thing to bed. And as I've stated, an assessment can be a broad range of stuff. If we had known the scope, and if we had known that there were 10 Bechtel guys there for 7 or 8 weeks, we definitely would have had follow-up questions.
And one of those follow-up questions would have been the extension of the schedule. That would have concerned you greatly, wouldn't it?
Yes, sir.
Because they were going to lose federal tax credits if they did not have the plan in use by, 2020?
Yes, end of 2020, yes, sir.
End of 2020, it had to be online. Otherwise, they'd lose, $2 billion?
I think it was $2.2 billion, yes, sir.
And then, of course, the cost would have been another factor of great concern.
Yes.
So that's how you have arrived at your opinion that had you had the Bechtel report in a timely fashion, even the preliminary report, you would have had a different reaction to how to proceed.
Yes, sir. That's definitely the case.
In hindsight, how would you have proceeded had it been handed to you?
Well, let's assume that if we were talking about that we received the Bechtel report, let's say we received the presentation. That would have prompted a lot of questions to SCE&G. And I think what we would have been looking at is they would have had to justify their current schedule. How are you guys coming up with this schedule? Let's look at the consortium has to come in here, and we have to look at the assumptions that Bechtel made. And I think, and quite honestly, I think it would have involved some continued participation by Bechtel, because it would have been a back and forth of, here are our unit rates. Because one of the things we never saw was exactly what unit rates are used by Westinghouse. They considered those proprietary, and I guess still do, although if you're out of the construction business, I have no idea why that would still be proprietary. But there would have been a lot of review, a lot of back and forth, and hashing out what we believe the true schedule should be.
And the cost.
Yes, sir. Yeah, I would just say that those things really go hand in hand.
Hand in hand.
Yeah.
The longer it takes, the more it costs.
Yes, sir. That's exactly right.
Thank you, sir.
Thank you.
Thank you. Any other questions, commissioners? Okay, Mr. Cox, do you have redirect? Okay, we'll take that up at 1:22. We're going to break for lunch right now. We are adjourned until 1:22.